Good morning, everyone, and welcome. This is meeting number 62 of the Standing Committee on Public Safety and National Security, Thursday, March 24th, 2011. In our first hour today, our committee will consider the supplementary estimates under Public Safety and Emergency Preparedness. The Honourable Vic Taves, Minister of Public Safety and National Security, is again appearing before us to answer questions on these estimates. He is accompanied by each of the top officials in his cabinet portfolio, including from the Department of Public Safety, Deputy Minister William Baker, from the Royal Canadian Mounted Police, Rod Connect, Senior Deputy Commissioner, from the Canada Border Services Agency, Ms. Cathy Monroe, Vice President of the Program Division. From Correctional Services of Canada, Commissioner Don Head, welcome back. And from the Canadian Security Intelligence Service, Laura Daniger, Deputy Director of Administration. And from the National Parole Board, Mr. Harvey Chernenko, the Chairperson. The Minister and his officials are also prepared to answer questions on the estimates following a brief opening statement, and then we'll proceed to questions from the members of our committee. And so, Minister Taves, welcome again to your committee, to this committee, Parliamentary Committee, and we look forward to your comments.
Thank you, Mr. Chair. Members of the committee, once again I welcome the opportunity to be with you to discuss the estimates of the public safety portfolio. As you indicated, Mr. Chair, I am joined here by the Deputy Minister of Public Safety, Mr. William Baker, as well as senior officials of the 5 agencies in the public safety portfolio: the Canadian Border Services Agency, the Canadian Security Intelligence Service, the Correctional Service of Canada, the Parole Board of Canada, and the Royal Canadian Mounted Police. The committee has before it the main estimates for fiscal year 2011-2012, which seek an increase in funds of $797.4 million over the fiscal year 2010-2011 for the portfolio. The committee also has before it supplementary estimate C, which seek approval for funds of $48.5 million for the current fiscal year. These estimates do not reflect initiatives announced in Budget 2011. As demonstrated in this week's tabling of the budget, the next phase of Canada's Economic Action Plan recognizes the importance of keeping our communities safe by investing in crime prevention and the justice system, with such measures including investing $20 million over 2 years in the Youth Gang Prevention Fund to promote the provision of community-based educational, cultural, sporting, and vocational opportunities for youth. Promoting safer Aboriginal communities by investing an additional $30 million over 2 years in the First Nations policing program to supplement existing policing services. Funding of $8.4 million per year to Canada's No Safe Haven policy for persons involved in war crimes, crimes against humanity, and genocide. Providing $26 million over 2 years to support the Federal Victims Ombudsman to promote access to justice and participation by victims in the justice system. Funding $20.9 million to continue to waive firearms license renewal fees for all classes of firearms from May 2011 until May 2012, and contributing $1.6 million annually to support security enhancements for communities victimized by hate-motivated crime. These are only a few highlights of this week's budget. However, they stand as a testament to our government's continued commitment to protecting the safety and security of all Canadians. The committee has before it the main estimates for fiscal year 2011-2012, which provide for the day-to-day operations of the portfolio throughout the fiscal year in accordance with our government's ongoing commitment to continue building safer communities for all Canadians at a time of government restraint. In addition, funds would be prudently invested to provide Correctional Services Canada and the National Parole Board of Canada with the resources to implement the Truth in Sentencing Act and the Tackling Violent Crime Act. It would allow the RCMP to meet incremental requests for policing services by provinces, territories, municipalities, and First Nations communities, while also implementing or renewing a number of initiatives to further crack down on the activities of organized crime groups as well as others who would threaten the safety and security of Canadians. It would strengthen the ability of the Canadian Border Services Agency to keep our borders secure while expediting the legitimate flow of people and goods across them, and allow the agency to support the integrity of Canada's immigration and refugee programs by implementing the Balanced Refugee Reform Act. It would deliver on the commitment I believe all of us share to protecting Canada's digital infrastructure from current and emerging cyber threats by providing needed resources for the implementation of Canada's cybersecurity strategy, which our government announced in September. Our efforts to tackle crime will cost more money. We understand there is a cost to keeping dangerous criminals behind bars, and we're willing to pay it. This is a small price to pay to ensure dangerous criminals don't create new victims or terrorize previous ones. We want to ensure Correctional Services Canada has the resources it needs to keep dangerous criminals behind bars and ensure that our methods and infrastructure keep up with, indeed get ahead of, new forms of criminality. The protection of Canadians must come first. As victims have repeatedly told us, releasing criminals onto our streets early has a much higher cost than keeping criminals behind bars. In fact, a recent report released by the Department of Justice estimated the total cost of crime to Canadians in 2008 to be $99.6 billion. And I'm very pleased that Conservative members of this committee have recently written the Parliamentary Budget Officer requesting a study analyzing the socio-economic cost of crime for victims, governments, and our communities. I agree with my colleagues on the committee that this is an area that has not received adequate priority and analysis. Our government is aware of the reality, and we are prepared to take the steps that will be needed to ensure that Correctional Services of Canada has the tools they need. The main estimates for fiscal year 2011-2012 seeks an increase to Correctional Services of Canada's budget of $521.6 million, of which $458 million relates to the implementation of the Truth in Sentencing Act, and a further $19.6 million is requested for the implementation of the Tackling Violent Crime Act. In addition, the main estimates for 2011-2012 seek an increase to the Parole Board of Canada's budget of $2.8 million, $1.6 million of which represents the third of 6 annual increases related to the government's Truth in Sentencing Act. Canadians have told us they want to feel safe on their own streets and in their own communities. They have told us they want police to have the resources they need to do the job. They have told us they want stiffer consequences and stiffer punishments for serious crimes, especially violent gun crimes. They have told us that they want offenders held more fully to account for their actions, and they have told us that they want the interests of victims put ahead of those of offenders, and that is what our government is doing. We are working with Canadians to restore faith in our justice system. All of us have been busy in this session. We have worked together on Bill S-13, which is the Protecting Borders Act, more commonly referred to as the Ship Rider. This is important legislation that would permit designated Canadian and American law enforcement personnel to jointly work on maritime law enforcement vessels in boundary waters and pursue criminals who try to exploit law enforcement gaps at our shared waterways. We have worked hard on Bill C-42, an act to amend the Aeronautics Act, which is important and very much needed by Canadian travelers, as it is going to allow Canadian airline companies to continue accessing southern destinations in the most timely and cost-effective way possible. And it is going to ensure that we continue to strike the appropriate balance between complying with international laws while also protecting the rights of Canadians. We've worked together to pass reforms to the pardon system, so that the Parole Board of Canada has the discretion it needs to determine whether or not granting a pardon might bring the administration of justice into disrepute. Our children have the right to be safe from sex offenders. That's why I'm very proud that all of us worked to pass legislation to strengthen the National Sex Offender Registry and the National DNA Data Bank so that all sex offenders are registered with the police. Tackling crime on all fronts remains a key priority for our government, which is why we also recently introduced legislation to combat the despicable crime of human smuggling. This is indeed a major concern for our government. We need the help of all members of Parliament to pass our firm and reasonable measures that would prevent human smugglers from abusing our fair and welcoming immigration system. Most recently, we passed reasonable measures to ensure that convicted con artists, fraudsters, and drug traffickers won't be released automatically onto our streets after serving just 1/6 of their prison sentence. Finally, our Justice for Victims of Terrorism Act passed through the Senate, and we have announced new RCMP technology that will help reduce wait times for individuals, including hockey coaches and teachers, to receive police checks to be able to work with the most vulnerable in our society. Keeping our communities safe has been a priority for this government, and I know it's a priority for members of this committee. We have taken action on a number of fronts to deliver on our commitment. We will continue to do so in the future, and I look forward to working with this committee over the coming months on a number of fronts to keep Canadians safe. I will now be prepared to answer questions, Mr. Chair.
All right. Thank you very much, Mr. Minister, for your words of your presentation this morning. We'll now move into the first round of questions, and I'm just going to remind all members from all parties that there's a lot of speculation going on in the media and around this place now. Emotions can run high. Let's make certain that all our questions are taken through the chair, and the same with the answers, that we have the best decorum that we can, and that's what we usually have here, and that's what I would expect. So we'll move into the first round of questions. Liberal Party, 7 minutes, please.
Thank you, Mr. Chair. Thank you for the Minister. I'm battling a cold, so excuse me if I sound a little stuffed up. Minister, if I could, I just want to run through history. And it has to do with cost, and I think it's pretty central to the estimates that are in front of us. It must have been about 2 years ago now that I made a request for the Parliamentary Budget Officer to review the cost of all the bills that were before Parliament that had implications with respect to incarceration. The Parliamentary Budget Officer agreed to undertake that study. And in that period of time, all I heard from his office was there was absolutely no cooperation from either your office or from Correctional Services Canada. In fact, it was so bad, he had to dedicate 1/3 of his staff, and he had to dedicate all kinds of resources to create statistical models to recreate the data that was refused to give to him. And the reason given was that it was cabinet confidence. Now, we move forward in time as the Parliamentary Budget Officer was blocked from doing his job, and Parliament was unable to know what the costing of bills were as we went forward. Mr. Chair, my concern is that it took the Speaker of the House to say that that behavior was completely inappropriate, that you cannot hide information from either Parliament or Canadians. And yet still the documentation was not handed over. There was a contempt motion passed by a committee of Parliament. And still today, nearly 2 years after seeking, with 18 bills before us, the Parliamentary Budget Officer tells us more than 55% of the data is missing. We don't have the information. So the question is simple. How can you expect Parliament to vote on bills for which it has no idea of the cost? How can you expect Canadians to weigh decisions about relative priorities when a blindfold is essentially put on them, not allowing them to know what the truth is? And why, Minister, do you refuse to hand over the documents, refuse to cooperate with the Office of the Parliamentary Budget Officer, and refuse to come clean on these costs?
Thank you, and again, I would ask that all questions be through the chair, please. Mr. Minister.
Thank you, Mr. Chair. Of course, it's been made very clear to members of the committee and all parliamentarians. I disagree with the analysis, I disagree with the summary, but what has been made clear by the law clerk for the House is that if members are not satisfied with the information that has been provided to them, there is the ultimate remedy that they vote against the bill. Now, in most of these cases that we've seen the bills coming through, members have voted for the bill. So they must have obviously been satisfied that the material was sufficient for them to make that determination. But in respect of the specifics, I would refer this to the Commissioner Head to talk about the cooperation that his office had with the budget officer.
Mr. Chair, I appreciate the offer, but I just want to come back to you, Minister, because the reality is it's not me or Parliament that has a problem with the numbers. It is
put, and we're answering the question.
No, but Mr. Chair,
basically I gave you 2 minutes on your question, and the minister has taken about 40 seconds on the answer. So he has asked Mr. Head very briefly. I'm going to try to keep the questions to the same amount of time as the answer, Mr. Head, very quickly. I'll give you. Yeah.
Sure. Thank you, Mr. Chair. In terms of the information that we provided to the Parliamentary Budget Officer, we provided all information that was publicly available at the time. I've subsequently met with the Parliamentary Budget Officer, and we've had some discussions about his methodologies versus ours. We've actually arranged meetings in the very near future to talk about how we go about developing assumptions and the costing models that are associated with those.
Thank you, Mr. Head. Mr. Holland.
The problem that I have is, again, so we're clear, Minister, it's not that I have a problem with the costs that are given. It's that no costs are given. Let's take the accelerated parole review. Now, we said very simply we want to know how much it costs. Now, in front of this committee, during debate, we were told you can't know. It's a matter of cabinet confidence. We can't tell you. Amazingly, the day after it was passed, we get a number. And by the way, we're told we're not really sure if that number's right. We're still looking into it. That's a past piece of legislation. Now, when you say cooperating, with all due respect, you know, very simple information, Mr. Chair. No, but through the Chair, I'm saying with all due respect, very simple information on head counts, projected head counts. I mean, these things should be obvious and readily available. My question is very simple. Just on one bill, we have more than 150 pages from the Parliamentary Budget Officer. I have never seen anything to refute anything in that document in a substantive or meaty way, and I'm wondering why you refuse to hand over. Right now, the Parliamentary Budget Officer, Mr. Chair, why, through you, Mr. Chair, the Minister is not handing over the more than 55% of documents the PBO says he needs to do his job. And can he not respect that Parliament can't make a determination on bills when A, we're refused to give the numbers, we're not given them at all, and B, when the Office of the Parliamentary Budget Officer says he absolutely can't trust the information because he's missing more than 55% of it, even 2 years after we've engaged this process?
Well, let me try to answer those to the extent that I can, and I'll leave the rest to Mr. Head. But because there are a number of questions that have been put, as I understand, about 4 or 5 questions that have been put here. The first question is the difficulty in attempting to determine the cost of any piece of crime legislation. And we went over that quite expansively in a prior committee hearing. It wasn't this committee, it was the Procedures Committee last week, and perhaps if my learned friend actually wants to know the answers to the questions that he's put, those same questions were put to his colleagues last week. But let me give one clear example. My staff at Corrections, the Commissioner, estimated that as a result of the Truth in Sentencing Act, there would be, by this time this year, an additional 1,300 or so new prisoners in the system. In fact, the number of prisoners was 500. Now, the correctional services diligently tried to determine exactly what the impact of legislation is. And there are all kinds of costing models. The question is not that they haven't provided the information. The question is that it's often difficult, if not impossible, to make these kinds of determinations. Similarly, trying to determine the cost of legislation, for example, my colleague, the Justice Minister, when it came to abolishing the faint hope clause, the elimination of the right to apply for parole after serving 15 years of a life sentence for murder. When you eliminate that, the issue is very difficult to determine what the cost is going to be 15 or 25 years down the road.
Mr. Minister. I'll move to the Bloc Québécois. Madame, vous avez 7
You have 7 minutes. Thank you, Mr. Chairman, and good morning to the Minister. Good morning to all your colleagues. Minister, I'd like to share a concern with you that was brought to my attention. And on the 15th of February 2011, a committee met on this issue. We asked the RCMP services to come and speak to us. And Mr. Henshaw, perhaps the RCMP representative could speak to us on that, was asked a question. 10 to 40% of criminal offenses were never registered in the criminal records registry. So there were criminal records that were actually never registered as such. Now, he told me he didn't know the answer to that question.
Estimates, and this issue really has nothing to do with estimates. It's dealing with an issue that we dealt with some time ago.
Je m'en viens. Oh, oui.
I'm getting to my point, Mr. Chairman. Microphone, please.
Donc,
Thank you. Minister, I'll just continue.
By this, it's my understanding when the minister appears on estimates that we're free to ask the minister anything within the portfolio of public safety. In his opening statement, the minister referred to many things that were beyond the estimates, including the pardon bill, all sorts of things. So I think we need to be clear that our questions do not have to be restricted to the estimates, but it's established in this Parliament absolutely that we can ask questions on the portfolio.
Mr. Davies, I think my answer was fairly clear that I will give broad latitude in the questions and perhaps even in the answers that are being asked. You're correct. It is a fairly broad thing, but again, I do tell you that we're here studying the estimates. So continue, Ms. Morani. I'll give you some extra time.
Monsieur le Président, que tous ces débats...
Mr. Chairman, I hope this debate will not count on my time.
Okay, merci.
Thank you.
Okay. Donc,
So as I was saying, Mr. Henschel responded that he did not have any monitoring tools in order to be able to measure the amount of or the whether criminal records were registered or not. Now, for 5 years now, your government has been repeating the same message to us, that you're all for law and order. I have to admit, Minister, that I'm very concerned when the RCMP tells us that 1.1 million requests have not been registered in the computer systems, that there's no monitoring system. So I made an access to information request for the RCMP because I had difficulty in believing the answer. I was provided with an answer and I submitted it to you. The RCMP stated clearly in response to my question with respect to the backlog, the RCMP responded that I have to pay for around $49,000 to have that information. That means that over 4,000 hours of labor would be dedicated to answering the question I asked on the number of records that had not been registered. What that means, Minister, is that the RCMP does not know how big that backlog is. And they don't know what the impact of that delay is on public safety. I would like to know if your department has investigated this. And I would like to know if there are any financial resources dedicated to this, and if not, if you're planning to provide any.
It's not my department, it's the Minister's department. But the questions can come through the Chair. Mr. Minister, please.
Thank you very much, Mr. Chair. I will turn that issue over to the RCMP, but I just make one observation that if that is the amount of time that is required to put that information together, you can see how complex and time-consuming an area this is. But I will allow the RCMP to answer the question.
Thank you, Mr. Chair. We do have a backlog in criminal records. Everybody that is either convicted of a criminal offense or is charged with a dual procedure or indictable offense is required to be fingerprinted. Those fingerprints are submitted. In most cases, those fingerprints are submitted manually. We are currently working on technology that will allow us to do that electronically and speed up the process. We're not there yet. We do have a backlog, and in some cases we have to refer to manual searches of documentation.
OK. Combien de retard? Je voudrais savoir combien de.
Then I would like to know exactly what the backlog is, because I put that question at the time. I asked, what is the delay, what is the backlog, and I was told that they couldn't reply. Are you able to respond to that question?
I can tell you that there are a significant number of records that are not electronically scanned right now that contribute to the backlog. I do not have an exact figure of how many records that would be. I would say it's in the thousands.
OK. Est-ce que ça veut dire que
Does that mean then that there would be about 1 million criminal records that actually haven't been registered electronically yet?
Continue, Mr. Nick.
I'm sorry, Mr. Chair. Yes. Again, Madam, I don't know exactly what the number would be, but it is quite high, and we're working hard towards turning that into an electronic format that will allow us, similar to what we do with real-time identification processes, and we can, into the future, we'll be able to turn that around in minutes, if not days.
Ce qui veut dire qu'actuellement un policier.
So what that means then, if there is a policeman anywhere in Canada and they enter the system, there are criminal records that policemen won't see.
There is that potential. Yes, there would be some cases where records wouldn't be in the system and wouldn't be called up when a police officer queried them.
Ben, merci beaucoup, monsieur. J'aurais une autre question.
Thank you. I have another question.
OK, j'aurais une question au ministre.
I would like to put a question to the Minister of Public Safety. Minister, you decided to close border posts at Jameson Line, Big Beaver, Morse Line. Those will all be closed, and these represent savings in some cases of about $500,000. Now, millions of dollars have been invested in Charbisco, which is the border service opposite us. Now, you said in your statement that you want to strengthen the Border Services Agency in order to protect our borders. But when you close border offices and you reduce the number of hours that they're kept open for, then you're not protecting our borders. What would you respond to that? Will you suspend that decision?
Our time is out, but if you would.
All I can say is that our hiring practices and the hiring of additional border services guards in excess of, I believe, somewhere in the range of 10 to 20% increase in border guards indicates our commitment to safety. All of these decisions with respect to the hours of operation of local crossings are analyzed by local CBSA officials who determine whether that is not only in the public safety interest of public safety, but in fact whether it's a value for taxpayers. Some of these border crossings will have under a dozen crossings a day. CBSA is the border services, the RCMP patrol the border generally. So not only have we increased border services, but we've increased the number of officers that we have in the RCMP. We take the border very seriously.
Thank you very much, Mr. Minister. Mr. Davies, please.
Thank you. Mr. Minister, I appreciate what you're saying about it being difficult to cost some of your bills, but I want to put a scenario to you that happened.
I assume you're talking to the chair.
Mr. Chairman, to the Minister through you. But I'll put a scenario to you that happened in this very building about 3 weeks ago. We were here on a Tuesday examining the bill that would end accelerated parole, and we had your Deputy Minister here, and we asked how much that bill would cost. And she said she couldn't tell us, it was a matter of cabinet confidence. That was on a Tuesday. On a Wednesday, parliamentarians went in and voted at third reading. And we voted on that bill, and it was passed without knowing what the cost was. On the Thursday, you and Mr. Head were again in this room, and you told us that the cost of that bill was $40 million.
Mr. Chair, it was me. It was
Chair, Mr.
me
Davies,
and Mr. Head,
we're just going to continue doing this through the chair.
Mr. Chairman, the Minister was in this room with Mr. Head saying on the Thursday that the cost of the bill was $40 million. Now, I'm wondering, if he knew that information on a Thursday, why couldn't this committee and parliamentarians know that amount of money on the Tuesday before we actually voted on Wednesday night and spent Canadian taxpayers' dollars without knowing what the cost was? Can you explain that to me?
Mr. Chair, I'm not familiar with the sequence of events that Mr. Davies has indicated, but I'll get back to him with that answer.
Thank you. Mr. Chair, the 80% of offenders in our federal prisons have an addiction. We know that mental illness is a significant and growing problem in our prisons. The Conservative government has said that there are people in prisons who shouldn't be there because they actually have health issues. Yet this budget doesn't say a word about increasing funding for mental health treatment or addictions treatment. And given that these are some of the prime causes of crime, and dealing with these issues is an absolutely identified way to reduce recidivism and make our communities safer, can you please explain why?
Well, I can talk about some of the initiatives that our government has taken in funding, for example, that was never in place under the prior government to address issues of mental health. We've contributed significant millions of dollars to the issue of mental health in prisons. This is an issue, Mr. Chair, that both the provincial and federal institutions are facing as a result in the shift of policy in the provinces that, some number of years ago, and I was a lawyer for provincial government during the course of those occurrences, that was essentially shutting down mental hospitals or asylums and putting these individuals out onto the street. And in many cases, not only were they then out in the street with mental health problems, but then they became prey to the drug dealers. So you have a double problem of mental health and drug addiction.
Well, given that, Mr. Chair,
so essentially these individuals then find their way into the provincial jail system and the federal institution. Now, we've taken steps to address it, but I think we need a more vigorous discussion with provincial mental health authorities about what would be a more appropriate way of dealing with these individuals, because the policies of the 70s and 80s of closing these institutions down have, quite frankly, not worked. And what we're doing is
Mr. Chair, I'm going to intervene. The minister's talking out my time. My question was not asking for a history of this. My question was why this budget does not have a single penny. No, the minister does this. He talks out the time and gives us long soliloquies about his past in the provinces.
Mr. Davies, just one moment, please.
I want to know why this budget doesn't have another dollar for mental health addictions. That's the question, not how we got to this stage.
Thank you, Mr. Davies. There's your question posed. That'll be all for you. Now, Mr. Davies, please.
Thank you very much. So as I've indicated, what has been happening then is the development of a parallel mental health system inside the provincial jails and inside the federal prison system. In terms of the resources that we are providing, Mr. Head can discuss that, but I can assure the committee members that it is a significant amount of money over a number of years.
Okay, thank you, Mr. Chairman. Well, there's no new money in this budget, and I guess that's the answer the minister doesn't want to say.
Well, that's
now,
not true,
I want to talk also about the budget. In this budget, Mr. Chair, there was no funding for a single new police officer in any of the municipalities in Canada. I want to ask the minister, does he think that there are sufficient police officers in the major cities in this country?
Davies?
Well, in fact, let's take a look at some of the steps that we have taken. The policing, in terms of the RCMP, for example, we've had the highest amount of recruitment in decades and the highest number of police officers on the street in Canada today than ever before. I don't have these statistics right in front of me, but those were statistics I've mentioned on other occasions, the number of police officers that are now on the streets. It's not simply, Mr. Chair, an issue of the number of police officers on the street. It's also ensuring that the laws are responsive to the law enforcement efforts of these police officers. It doesn't matter how many police officers you have on the streets if the laws simply release these individuals that they arrest the next day.
Well, Mr. Chair, I think that's where we differ. I think it does matter how many police officers we have on the streets. Now, I notice in the budget that the budget for emergency preparedness is being cut by $26.1 million. That's 5.9%. Given the events in Japan, where we see the devastating effects of an earthquake, and given that in my home province of British Columbia, where we sit on a seismic zone, and in fact the minister actually did and then said there was a tsunami warning on and it was off, can the minister tell us why he is cutting $26.1 million from emergency preparedness at a time when we should be bolstering our emergency preparedness in this country?
Davies, Mr. Minister.
Just to correct the record, Mr. Chair, I've never said that the number of police officers on the street isn't important. It is very important. What is equally, if not as important, is the fact that you have to have legislation that is enforceable and actually keeps prisoners behind
now to the question. I'll give you time. Now to the question.
In respect to the specific question, I can leave that to Mr. Baker.
Yes, Mr. Chair. The mains are indeed reflecting a reduction in the funding for emergency management. Part of this $2 million is actually a technical adjustment. The money is being transferred to Public Works and Government Services, but it is still with respect to emergency management. There are also some sunsetting provisions on particular projects that do not need to be carried forward. Core funding is largely in place. There are some efficiency measures as a result of strategic review that we feel we can accommodate without compromising in any way our functionality on emergency management.
Thank you very much, Mr. Baker. We'll now go to Mr. Lobb.
Thank you, Mr. Chair, and thank you to the Minister and all the heads that are here today. First question, Mr. Davies touched on it, and it's to do with the disaster financial assistance arrangements are there. It's a significant component of the main estimates, and I wondered if there was anything that the Minister or Mr. Baker would like to add to their previous answer.
Well, Mr. Lobb, thank you very much through the Chair. Mr. Chair, Public Safety Canada administers the disaster financial assistance arrangements on behalf of the government. The provinces and the municipalities are, in fact, the first responders, if I can use that term, in meeting the costs of the response and recovery following a natural disaster. The costs then are recoverable through the DFAA. There's been a number of amendments that we've made to the DFAA, and certainly will benefit areas like my own province, which has experienced a flooding. Indeed, many individuals in my riding and the city of Winnipeg, of course, are very worried about the impact of this flooding at a time when Parliament should be, in fact, focusing on very practical issues like the flooding in Manitoba. Unfortunately, the opposition opposition parties appear to be focused on having an election. So in my province of Manitoba, we'll be having an election because of the opposition at a time when my energies as a regional minister should be focused on ensuring that we coordinate matters with the province in terms of delivering disaster assistance. In respect of some of the specifics, Mr. Baker can deal with that.
Just briefly, Mr. Chair, I think it's important to note that when we're talking about the budget that's allocated for the Disaster Financial Assistance Act, it's essentially a notional amount. It's established at roughly $100 million every year. It is demand-driven. If we receive more demand in a given year because of it, flooding, hurricanes, whatever, then we would pursue additional funding through supplementary estimates.
Okay, I would suggest that many Canadians, if not most or all Canadians, would agree that criminals need to be punished and they need to serve the time that they've been sentenced to. And but another piece to that is to try and prevent these people from going down the way of crime in the beginning. And I wondered if the minister would be able to answer the level of funding that's been committed to the Youth Gang Prevention Fund for this year, 2011 and 2012, because I think it is important that we try and reach out to these youth before they enter into a life of crime.
Thank you very much, Mr. Chair. In answer to the member's question, I was very pleased to see the Prime Minister announced very recently in Vancouver an extension of the Youth Anti-Gang Initiative and the money that is being put forward in that respect. At the same time, I was able to be in Saskatchewan just very recently, announce a number of significant projects, community-based projects, where there are individuals working with young people to keep these young people out of gangs. It's quite interesting that we have made a record amount of commitments in terms of funding for our National Crime Prevention Program. The amount of expenditures in respect of these programs that are focused on keeping young people out of gangs and out of a criminal lifestyle amounted to a commitment of $40 million in the past fiscal year. And as I say, this is a record amount of money spent on this type of initiative. I'm very pleased to see that type of initiative continue. I'm pleased to see the Prime Minister announce the extension of the program in Vancouver, and I trust that members will support the budget that brings in this type of funding to help youth prevent a life of crime.
Thank you, Minister. Mr. Lobb, you still have 2 minutes.
Okay, thanks again. Another question I have is regarding the First Nations policing program, and I wonder if the minister would be able to tell Canadians a little more about the program and the amount of funds that have been allocated to it for this fiscal year.
The First Nations policing program is a very important part of improving public safety in First Nations and Inuit communities. It's been going on for close to 20 years. In fact, funding, approximately $17 million for the First Nations policing program, will sunset on March 31st, 2011, and therefore the mains of public safety main estimates will therefore reflect a return to ongoing funding. The short-term funding was intended to provide for the sustainability of policing agreements under the First Nations policing program and conduct a comprehensive review of the program. So Budget 2011, in fact, puts forward $30 million in additional funding so that we can, in fact, keep police officers on the street, as perhaps in reference, Mr. Chair, to the question put by Mr. Davies about the commitment that our government has to having police officers on the street. Very important. Unfortunately, it appears that the opposition is determined to end the budget and and that funding will not be in place when funding lapses on March 31st.
Just closing comments, Mr. Lobb. You have 30 seconds.
Maybe time for just a quick question regarding CSIS, and if you could tell us how the funding's changed from year to year, and as well as the effectiveness of those expenditures.
Well, perhaps Ms. Daniger can respond to that very quickly.
Sorry. Chair, thank you very much. Is that from my BlackBerry? Take the okay. Sorry about that. Our funding increase over 10-11 is very marginal. It's gone up by about $2.5 million. A lot of that has to do with the program integrity funding that we got in budget 2010, which was received for some specific projects that the service is going to be putting in place, which I can't really talk about the details because of the security issues around them, unfortunately. We also got some funding in 2007 through the budget, again to deal with some of the resource integrity issues that the service was facing. Our budget since 2000 has increased by about 134%, largely due to the events of September 11th, 2001. But we also got some money for a Phase 3 tower at our Ogilvie Road campus, which we have actually nearing completion in April.
Thank you very much. We'll now move to the second round. Madam Mendez.
Thank you, Mr. Chairman. I'd like to ask you, if possible, Mr. Chairman, to confirm with the Minister whether or not he did state in the House that he was familiar with the numbers and that he did have all the costs for programs and bills that were being submitted, because it's only after the bills were passed that we have been told that those details are not available. I'd like him to explain that inconsistency, because on the one hand he says he has the numbers but he can't share them with us, but on the other hand, after the bills, he says he's not too sure of his numbers.
To the extent that those numbers are available, I'm familiar with them, and if there's any specific numbers that the member feels that she doesn't have, she could put that question to you, Mr. Chair, and departmental officials can provide that information.
I would just like to recall to the Minister, Mr. Chairman, that for Bill C-59, that was one request that was put in, and it was only once. Well, we still actually don't have the numbers, but 55% of the bills that were tabled were not accompanied by the numbers that we needed. Now, I'd like to have some information on the cuts that were made to the RCMP and to the External Complaints Board.
To the RCMP, public complaints.
Do you want to?
It's about a 19% cut, so I would like to know why something has been cut when it is so important for so many individuals involved in public safety.
I'm not familiar with cuts, and I'll have the RCMP.
Madam Mendez, is it a specific line item, or is it the overall budget that you're believing in?
No, it's a specific. I'll say it in English. Royal Canadian Mounted Police External Review Committee. There's an 18.9 cut in the budget, and it's it's a line budget.
Maybe in regards to the grievance process, an internal, the internal.
Up to the minister to know.
Mr. Baker.
Mr. Chair, there is a decrease of $342,000. And this is the end of what was always designed to be temporary short-term funding for the External Review Committee. The cut is parallel with some shrinkage in the size of that organization, given that with the tabling of Bill C-43, which will establish a new labor relations regime for the RCMP. The External Review Committee would cease to exist upon coming into effect of that legislation. So this is a transitional measure that is explainable by the changes in the machinery.
Merci beaucoup.
Thank you very much. Now, I'd just like to come back to the Canadian Border Services Agency. We heard testimony to the effect that there were negative economic consequences to the cutting of various border crossings. Now, yes, it's true that there is a low level of flow, but often that flow is economic flow, whether it has to do with trucks or merchandise. So, through you, Mr. Chairman, I would like the Minister to explain why these crossings are being cut, when the witnesses we heard all agreed in saying that a good part of the trade between the eastern United States and eastern Quebec happens through those crossings.
Madam Mendez, Mr. Minister.
Information that I have, and I have to point out, Mr. Chair, that these are decisions made by local CBSA officials who look at the amount of travel. For example, Jameson's line in Quebec, which is one of the ports of entry that is being closed, sees an average of 12 travelers a day and no commercial vehicles. No commercial vehicles. There's a 24/7 port of entry 10 kilometers away. The Franklin Centre, which sees an average of 56 travelers a day and 3 commercial vehicles, there is a 24/7 port of entry 16 kilometers away at Herdman. Finally, there's one in Saskatchewan, for example, Big Beaver, Saskatchewan, which sees an average of 5 travelers a day and no commercial vehicles. There is a crossing 28 kilometers away which has the same amount of same hours, which can provide that. So we take a look at the issue of how these border crossings are being used, and I think taxpayers would agree that this is a prudent use of that, given that there's virtually no commercial traffic at any of these and a very limited amount of ordinary travelers using those, and there is an alternative not too distant.
Your time's up. Thank you very much, Madam Mendez. We'll now move to Mr. McKenzie.
Thank you, Chair. Thank you to the Minister and the officials that are appearing before us. Mr. Chair, as you know, much of this committee time has been drawn from time to time, at least on the costs and the difference of what the Parliamentary Budget Officer has forecast and what, in fact, I think we have heard from people like Mr. Head, who has a very good grasp of what the cost is for the cost to run the prisons. And Mr. Chair, I think we heard the Parliamentary Budget Officer and his staff indicated a cost of something in excess of $300,000 per inmate, and that was based on some assumptions that he had built into his model. I'm just wondering if Mr. Head could tell the committee, Mr. Chair, what in fact the actual costs are for inmates in the Correctional Service of Canada facilities. Because I think there is a significant difference, and I think I read an article in one of the papers this week from an independent academic who suggested that the Parliamentary Budget Officer's assumptions were way off, and as a result, based on his assumptions, his final tallies don't accurately depict the cost. So I'm wondering if Mr. Head could give us those actuals as opposed to what we did here.
Mr. McKenzie, Mr. Head.
Thank you, Mr. Chair. I'll give the committee the breakdown of costs by security levels, by offenders in institutions, and by offenders supervised in the community. So on an annual basis, it costs us $150,808 for offenders in maximum security, $98,219 for offenders in medium security, $95,038 for offenders in minimum security, Women in the women's facility is $211,000 and $211,093. To administer our exchange of service agreements with the provinces is an average of $89,800. So the average cost for somebody incarcerated is $113,974. For offenders that we manage in the community, for those offenders that are in our community correctional centres, the cost is $66,993. For those offenders that are supervised under parole in the community, the cost to us is $27,455, and the total average cost for offenders in the community is $29,537. And the total average cost for both institutional and community offenders combined is $93,916.
And thank you. And I think that, Mr. Chair, perhaps illustrates where there are a great deal of differences between the parliamentary budget officer's calculations and perhaps what the opposition are frequently talking about, large numbers in the House, because I don't think the facts actually bear out those allegations. The other part of this whole equation is that I think that some of this legislation has now been in place for a year, some of it a little more than a year. And I know you told us at a previous appointment, Mr. Chair, we heard from Mr. Head, I think, a few weeks ago, and where Mr. Head had indicated they had contemplated or expected a certain level of increase that didn't occur. And I'm wondering if Mr. Head has some numbers that he could share with us of the experience of a year of the legislation, if in fact the numbers are higher or lower, or if they're right on what may have been anticipated. But I think my sense is it illustrates the difficulty in trying to project forward based on what the legislation is going to have. So I'm wondering if Mr. Head could provide us some of that background.
Thank you, Mr. McKenzie. Commissioner Head.
Thank you, Mr. Chair. As the Minister pointed out, our initial projections for this first year were approximately 1,300 offenders would be coming into the system that were not anticipated. As of our count at the end of February, we were 520 offenders more than we were at the same time last year. So our actual inflow is lower than our anticipated costs. As both the Minister and I have pointed out in the past, we monitor these figures very closely on a daily, weekly, monthly basis. We, in our earlier assumptions in terms of the uptake of, for example, what's called C-25 by the judiciary, did not occur at a rate that we anticipated, so that's part of the numbers. There still may be an increase coming in the near future, or it may be at the lower rate that we're seeing now, but we continue to monitor that very closely.
I think there's one other important thing that Canadians should know, and I'm sure that Mr. Head can answer. If he would give us the age of some of the existing facilities that certainly projected in the future will need either major refurbishing or replacement. I know.
Very quickly, Mr. Head, our time is just up.
Sure. On average, our institutions are about 40 years old, and the oldest in my fleet is older than Confederation, and that's Kingston Penitentiary, which first came into use in 1835.
Thank you.
I want to thank the Minister and all the department heads for appearing today. Certainly, when we come into the times where our committee looks at the estimates or the supplementary estimates, we very much appreciate not only when the Minister appears, but also when he brings the department heads. So thank you for that. We appreciate it very much. We are going to suspend for just a few moments, and then we will resume committee. We'll suspend. In our second hour today, we'll reconvene our committee. I'll bring everyone back to order here. In our second hour today, we will continue our hearings on Bill C-23B, an act to amend the Criminal Records Act. Appearing before us, we have, first of all, as individuals appearing, Mr. Randolph Fletcher, a sexual deviance specialist, and also William Marshall, Director of Rockwood Psychological Services. And from the Vancouver Police Department, Warren Lemke, Deputy Chief Constable. I know another Warren Lemke, and I was thinking, Warren Lemke is going to appear here today, but I see it's a different individual. But we certainly welcome you from the Vancouver Police Department. I also understand a number of all of you have opening statements, and if we could hear them, we'll go into the first round of questioning. Our intentions are to adjourn or to suspend approximately 15 to 10 minutes before 1:45, and we just have some committee business that we must take care of. So perhaps, Mr. Lemke, I think maybe you've traveled the furthest to be here, or if you would begin, please.
Thank you very much. It's a pleasure to be here. My first trip to Ottawa, and it is a beautiful city. Good morning. It's an honor to appear here today to give comment on a bill that has the potential to impact both public safety and confidence of the public generally, but especially victims regarding the justice system. In the past few years, there's been much focus and public attention on the issue of pardons in Canada. This, of course, has precipitated this bill. There are many elements of this bill that I would suggest the policing community would support, as they will assist us in protecting the public. First, changing the name from pardon to record suspension is important as it recognizes the victims in this process. Victims can be impacted by crime long after any pardon or record suspension is given. In many cases, they would never pardon the criminal. It is a very positive step that the National Parole Board will now have much more authority when it comes to granting, denying, and revoking the record of suspension. With regard to extension of ineligibility period for application and concerns about how that can affect people, we need to remember that although the bill recommends summary conviction offences have a 5-year waiting period and indictable offences 10 years, through the use of absolute and conditional discharges, there are 2 other periods. 1 year for absolute discharges and 3 years for conditional discharges, where these records are automatically removed either immediately or upon successful completion of the probation period. Many of these sentences are given out especially with first-time offenders, so they don't have to wait the longer period imposed by this proposed bill. I note that out of the 400,000 pardons given since 1970, 96% are still in force. An important figure, but what about those who've been given pardons who have just not been caught? I do find it interesting that it appears that a very large number of pardons have been given out in the last few years. And I also note that based on figures given in the last 2 years, hundreds of sex offenders have been pardoned. This is very troubling. Some sex offenders, especially predatory criminals and those pedophiles who prey on children, are arguably never cured. If any are included in that group, the consequences could be tragic, and I note again that these individuals were pardoned in just the last 2 years. And it should be noted that, according to Statistics Canada, sex offences have one of the highest rates of underreporting in Canada. There will likely be concern around the issue of no eligibility for those who are convicted of certain sex offences against children or have 3 convictions for indictable offences. Anyone who would commit these sexual offences against children is a predator. As I said previously, it is well-established fact that many of these predators can never be cured, so in light of that, they should never have a record suspension. It does make sense, though, to allow the noted exceptions which relate to certain sex offences against minors by offenders close in age, as I think the public would understand this rationale. The issue of ineligibility where a person has been convicted of more than 3 indictable offences is one that I respectfully suggest requires some discussion. A young person could be convicted of 3 break-and-enter offences when they're in their late teens, early 20s, and if they clean up and they're in their 30s and 40s, should they still be ineligible? Overall, I believe the police community and the public would support this bill and its intention to allow those who have reformed to have a clean slate to get on with life and be a contributing citizen. Those who continue to re-offend or commit sex offences against children should not get this privilege. And having the National Parole Board given the authority to make an informed decision in all cases can only be seen as positive. This bill should turn around the public perception that pardons are just there for the asking.
Mr. Lemke. Perhaps we'll just work our way down the table here. Mr. Fletcher, please.
Yeah, just to give a bit of background, I know I have a bit of an unusual title as sexual deviance specialist. It's caused me no end of embarrassment sometimes. But basically, I work for the Attorney General's Department of Province of Princess Edward Island. And in that position, I provide assessment and treatment to anyone who's been convicted of a sexual offense in the province, or anyone who's presenting with deviant sexual urges, fantasies, or behaviors, regardless of whether or not they have a criminal conviction. I've been doing that for the past 16 years on a full-time basis. Prior to that, I worked for mental health services doing the same thing on a 50% basis. I've been qualified as an expert witness in this area by the Supreme Court of PEI. And in a previous position where I worked with mental health services, I also provided treatment to victims of sexual offenses. In 1994, I was awarded the Lieutenant Governor's Award for Crime Prevention in recognition of my work in establishing a very comprehensive assessment and treatment program for persons who have committed a sexual offense. My motivation for this work is that I'm very concerned with crime prevention, particularly preventing crimes against children. And it's in that regard I'm speaking today. The Canadian justice system recognizes that people who commit criminal offenses can be rehabilitated and contribute positively to society. Treatment and rehabilitation programs for people who commit all categories of criminal offenses have been proven to reduce reoffending. While punishment on its own has been found overall to either have no effect or, in the case of more severe punishment, the negative effect of actually increasing reoffense rates. In order to justify the denial of record suspension for a category of criminal offense, there has to be a compelling reason. For example, if there is scientific evidence of a high reoffense rate for a category of a criminal behavior, if the effects of that behavior on victims has been established as always being greater than for other types of offenses, if it was established that rehabilitation of people who commit that type of offense was not effective, and finally, if it was established that there are no significant differences between persons who commit that type of offense. Given scientific evidence of those things, it could be argued that record suspension be denied to everyone who commits a sexual offense against a child. In passing legislation that has an impact on any criminal population, it is also important that there be an awareness of the possibility of unintended consequences. Legislation aimed at making communities safer could have the unintended effect of actually increasing reoffense rates by interfering with the person's rehabilitation into society. In considering legislation that would deny record suspension to anyone who has been convicted of a sexual offense against a child, the following 4 points should be taken into consideration. First of all, people who have committed a sexual offense against a child are not a uniform group. They differ significantly in terms of motivation, dangerousness, degree of dysfunction, and the risk to reoffend. Second, the sexual reoffense rate for people who commit sexual offenses against children is not high. Most do not reoffend. Compared to many other categories of criminal behavior, the reoffense rate is relatively low. Third, treatment and rehabilitation of people who committed a sexual offense against a child has been proven to be effective. I can tell you, for example, that in a study in 2006, with people who completed treatment in the province of PEI, the reoffense rate over a 5 to 10 year period was between 3 and 4%. I believe Dr. Marshall can give you similar statistics for his program. Finally, the effects of sexual victimization of children can be very severe and lifelong and should be taken seriously. However, there is a continuum of harm. And while no level of harm to a child is acceptable, not all offenses produce severe or lasting trauma. Research has shown that the most damage to children is actually caused by exposure to domestic violence, while children who have been physically, verbally, or emotionally abused experience similar effects, both in type and severity, to those who have been sexually abused. Just to put this in perspective, it's important to understand that the verbal or emotional abuse of children, which can produce very severe effects, is not considered a criminal offense. In summary, people who commit a sexual offense to a child are not all the same. Most do not reoffend. Treatment aimed at reducing the risk to reoffend has been proven effective. The effects of sexual abuse on children can be serious and lifelong, but there are other types of abuse and criminal behavior with similar or more traumatic effects. A one-size-fits-all approach is not appropriate. Our system already contains provision for denying pardons to those who sexual offenders who are dangerous and who continue to pose a high risk for sexual offending. I'd also like to briefly address the risk of unintended consequences. Labeling theory, which was developed by sociologist Howard Becker, holds that deviance is not inherent to an act. Instead, it focuses on the tendency of majorities to attach negative labels to people who are seen as deviant from what is seen as normal or acceptable. The theory is concerned with the self-identity and behavior of individuals and how that might be influenced or determined by the terms used to describe them. This can become a self-fulfilling prophecy in which a person decides, this is what I am, I cannot change, so I may as well accept it. The passing of legislation that would universally deny suspension to anyone convicted of a sexual offense against a child would deliver the following message. You have been singled out as among the most dangerous and damaging members of our society. There is nothing that you can ever do that would ever convince us that you can be rehabilitated or that you are worthy of pardon. It is important to consider the effect this could have on the motivation to attend treatment programs and to change behavior. And finally, an important component to the rehabilitation of anyone who has committed a criminal offense and has been released into the community after a period of incarceration is the attainment of gainful employment. It is well established that a criminal record can be a deterrent to obtaining a job. For someone who has a record of sexual offending, this is particularly true. Denial of sentence suspension can further prolong that difficulty.
Mr. Fletcher. And now to Mr. Marshall, please.
Thank you. Thank you for inviting me, and it's a pleasure to be here. I've been doing treatment and research with sexual offenders for the past 42 years. I was a professor at Queen's for 28 years, and they gave me the opportunity to do this kind of work. I've consulted to somewhere around 25 countries around the world, helping them design treatment programs for sexual offenders in their prison systems. And I've set up programs in, I think, 6 different countries around the world for sexual offenders. I have 380 publications, including 19 books, most of which deal with sexual offenders and their treatment. I have contracts with Corrections Canada, amongst other contracts. And we've been providing treatment in corrections facilities in Ontario for off and on for the last 30-something years. I started the very first treatment program in 1973 in Kingston Pen. It was the first in the country. We've been following our offenders very carefully. We have, for example, a cohort of 535 that we've now followed for an average of 10.5 years. Of those treated 535, 5.2% have reoffended over that period of time. Reoffences amongst sex offenders, whether treated or not, most of them occur within the first 3 to 4 years. So I think we're on safe grounds to say that this program is very effective. Corrections Canada has been at the forefront in the world of providing rehabilitative services to all manner of offenders, and particularly sexual offenders. One of the problems with treating sexual offenders, by the way, I concur with Mr. Fletcher, that the average reoffence rate of child molesters untreated is 18% over a 10-year period. This is not a remarkably high level of reoffending compared to other types of crime. One of the problems in getting sex offenders into treatment is that they need to see some value to themselves. The opportunity for parole is a very important motivator in getting these men in prisons into treatment programs. as is the opportunity to function within a programs-oriented prison rather than a non-programs prison, as is finally the opportunity to find some redemption in securing pardon. Of course, no sensible community would give pardons to all sex offenders. What they have to do, in my view, is they have to demonstrate, first off, that their dangerousness and risk to innocent children has been reduced, and the best way to do that is through effective treatment, both in the prisons. Corrections Canada has the good sense to also require most sex offenders, and particularly child molesters, to do follow-up treatment in the community once they're released as a condition of parole. I think the incentive of possibility of a pardon is, I think, quite crucial. But, of course, there are some people that I would never recommend a pardon for, and I could string off a bunch of names familiar to all of you, I'm sure. But, I mean, we have to have discriminatory procedures. You have to discriminate amongst the level of risk, the efforts that the person has made to rehabilitate themselves, not just through treatment programs, but by their good behaviour in the community. We can talk about unidentified crimes, but you know that's like talking about it's like knitting clouds, as one of my colleagues used to say. It's an unknown. We can't know how many unreported offences in any particular individual occurs. All we can go by is the official record, their behaviour, information that the parole board can take into account in deciding on whether or not to give them a pardon. So I would strongly oppose the idea of just wiping out pardons altogether. I think the incentive of a pardon is very important, but we need to make sensible decisions about that and be, I think, quite conservative about it.
Much, Mr. Marshall. We'll move into the first round of questioning. Mr. Holland, you have 7 minutes.
Thank you, Mr. Chair. I think what's difficult about this issue is there's a lot of folks who are lumped in to this bill. Now, the history of it was we dealt with 23A, and that's something that Parliament did collaboratively at the end of last June to find a compromise where I think all parties believed there were cases where reforms and change needed to be made. Arguably, they should have been made many years ago. But the concern that we have now is in questioning the minister, and in fact, questions even from Conservative members, there's an acknowledgement that this is trapping a lot of folks that were not intended. And Mr. Lemke, is it Lemke? Lemke. Mr. Lemke, maybe I'll pose this question to you as an example. The minister agreed that somebody who... Through the chair. It's the first day we're doing this, Chair. I guess I'm getting used to your new system after all these years. So through you, Mr. Chair, when you have somebody as an example who was before this committee, who was a victim of the residential school program, made some mistakes as an 18-year-old. These were not sexual assaults. Had been crime-free for many years. Now was a leader in his community, making a difference, helping people in Aboriginal communities lift up out of the situation, somebody who dealt with terrible abuse in his lifetime. This bill would stop him from getting a pardon. It would mean that he wouldn't be able to get a good job. It would mean that he's not able to travel to other places. We also heard testimony that for somebody, as an example, an 18-year-old mother who made a bad decision and wrote bad checks, 4 or 5 bad checks, because that would be 4 or 5 offenses that she similarly would be hit by this legislation and not given another chance. And so what bothers me is that Conservative members in committee will express sympathy for witnesses who express this viewpoint. And the minister will even express sympathy and say, yeah, there's change. And said here in committee, change needs to be made. And then we'll stand in the House and say, I stand for sex offenders, because I asked those questions. I mean, it's outrageously dishonest. And so I guess I would ask you, would you agree with me that those portions of the bill that in particularly are dealing with the folks that I've just described, that's something that needs to change before we pass this legislation?
Mr. Holland, Mr. Lemke.
I think, Mr. Chair, that is one portion of the bill that could be looked at, but I want to expand on that a little bit by saying that you can't just look at the individual and there are many factors that have to be considered, including the fact that the individual may have been given absolute or conditional discharges before convictions and indictable offences. You also have to look at the reality that with many chronic offenders, they commit 10 offences before they're ever convicted. They'll do 10, get convicted for 1. Having said that, there's a lot more that you have to look at. You have to look at the individual and their entire contact with the criminal justice system and the police. Having said that, I have met people in my 26 years of policing that have turned around.
Well, sure, and in fact, we know the rate of violent recidivism in Canada is less than 1%. So the point is that, you know, I think when we're crafting this, we have to be careful because these are real people. And we have to remember that after a lot of years of no instances of any repeat offenses, when you have somebody like the gentleman that we heard here, not just the fellow who went through the abuse of the residential school program, but somebody who now all committee members acknowledged was doing fantastic work as an entrepreneur, as a tax-paying citizen, saying he can't grow his business because he can't go to the United States if he doesn't get a pardon. Somebody who was selling steroids, clearly a mistake, but clearly somebody who's reformed and is now an advocate for making people better. And why would we, and maybe to the other witnesses, I mean, why would we throw brick walls in front of people who clearly have turned a corner? Why would we seek to block them from becoming good tax-paying citizens? Why would we block them from growing their business or helping other Aboriginal youth, making sure they don't make the same mistakes? I mean, that's what this bill is doing in different parts today. And so, you know, that's what I'm saying here. Absolutely. You know, frankly, a number of years ago, there's elements that we could have tightened. But the argument that I'm making on pardons is let's make sure that we're not throwing brick walls in front of those folks who deserve another chance. You know, who made mistakes when they were 18 and 19, but deserve their shot at redemption, right? And I mean, that's fundamentally what rehabilitation and our incarceration system is about, right? Is it not?
Correct, as long as you look at the entire picture and you say, how many absolute discharges? How many conditional discharges? What were the crimes? They might have been crimes of violence. They might have been property crimes. They might have done 40 residential B&Es.
But I guess my point is...
So, if I could just finish, Mr. Chair, that as long as we're looking at the entire picture, you can't just say more than 3.
But you're kind of making my point, because you're saying you got to look at the situation. No, well, through you, Chair, again, it's hard to get used to this new system after so many years. But through you, Mr. Chair, you know, look at, you're kind of making my point, or he's kind of making my point. When you take a look at the, fact that you're saying we have to look at the circumstances, we got to look at the individual cases. This kills that. This bill removes that possibility. It blankets a rule across the entire spectrum. There's no possibility of doing what you're saying. Everybody gets caught up in this. The people we had in committee, that every single member of committee, and if they've changed their mind, if any of the Conservative members have changed their mind about the witnesses we had before that they expressed sympathy for, that they felt were doing a good job and it turned their lives around, then please express that. But the point is that it captures everybody. It removes discretion. I mean, is that not something that concerns you?
It does, Mr. Chair, because I have seen people who have been redeemed.
Thank you. Okay.
Thank you, Mr. Chair.
Mr. Chair, if I could just add,
yeah, you still have
I am only referring to the topic that was brought up. I'm not referring to child sex offenders.
And this is an important point, Mr. Chair, because every day in the House of Commons, I'm attacked as supporting child sex offenders, and I've been very clear in this committee that I support the portions of this bill that deal with serious violent sexual offenses. But let me be equally clear that in a blanket fashion, destroying all discretion and throwing walls in front of people who are moving forward with their life is a mistake, and that's something I won't support despite fear-mongering.
Thank you, Mr. Holland. Madam Morani.
Ms. Morana, thank you, Mr. Chairman, and thank you for coming today. Welcome to you all. This bill has 2 points that are of interest to me. There's the issue of ineligibility. So, in other words, an individual could no longer put in an application after 3 offenses for a pardon. Now, we're against that because someone may commit 3 thefts and be perfectly able to be rehabilitated. Now, there's another part of the bill that is also of interest to me. No longer granting a pardon. I'm going to continue calling it that because the name hasn't been changed yet. The word hasn't been changed yet. So for sex offenders, child sex offenders, there's this issue of no granting a pardon. Now, I support this because pedophilia is a disease and it can't be cured. And I'd like to put the question to Mr. Marshall, who's an expert in this field. Does he feel that pedophilia is a disease? And if so, can it be cured?
Thank you. I don't think the concept of disease is particularly relevant to this issue, but let's set that aside for the moment. The question is, can they be rehabilitated in a way that reduces their reoffending? Right? The answer to that question is absolutely unequivocally clear. There have been two large-scale meta-analyses, for example. Meta-analyses are a statistical procedure for clumping together a whole range of studies and making them essentially into one. One of those studies by Friedrich Lozel and his colleague, published in 2005, had a sample size of 22,000 sexual offenders from across the world in a variety of studies, representing the average reoffence rate you would expect in the untreated group, about half of the 22,000. In the other half, the treated group had a recidivism rate that was substantially and statistically lower than the untreated group. It was less than half of the reoffence rate of the untreated group, right? And that's across a whole range of treatment programs, some of which I wouldn't think were much good. So it's very clear from that and a variety of other studies.
I understand the point you're making, and I understand that what you're saying is that when a sexual offender is treated, the risk of recidivism is less, depending on that offender. Now, but that wasn't my question. My question is this. Pedophilia is a deviance, and it can be controlled depending on the individual, but it cannot be cured. And I think you're perfectly aware of that, Mr. Marshall.
In the very first place, pedophilia is a diagnostic label. And the question that always arises about diagnostic labels is, are they reliable? That is to say, if I had two psychiatrists see the same client, review the same set of records, would they come to the same conclusion? The answer with respect to pedophilia is no. The disagreement is huge. You can't talk about whether it's a disease or not if people cannot agree, experts can't agree on whether it actually exists in this particular person. So it's an irrelevant question.
Then, in that case, why is pedophilia in the SM4, DSM-4 if it's not a disease?
About this. I'm not against anything being in the diagnostic manual so long as it can be demonstrated that it can be diagnosed reliably, and the clear case is that it cannot be, and the DSM's own committee investigated this and found levels of reliability that were far too low to be acceptable.
Est-ce que j'ai le temps encore? Have any more time? Yes? When you refer to the level of recidivism, when you're looking at that level, you're not necessarily saying that someone has reoffended or not. For example, let's take a pedophile who is offended and then is not necessarily able to kill a child, but rather assault a child. Then you say that there has been a certain amount of success rate. So what I'm saying is that when you're speaking about recidivism, and there's a decrease in the level of how dangerous an offender is. Let's take a pedophile, for example, who killed a child after raping that child, and then they undergo treatment, and they rape a child, but they don't actually kill the child. That counts as a certain amount of success.
It wouldn't count as success at all for me. I mean, if he reoffends, he reoffends. I mean, it'd be very interesting if the harm that he does was reduced. I would count that as somewhat positive. But, you know, I don't have any reservation about barring
Mais est-ce que le taux de récidive, quand vous évaluez les taux...
When you're looking at the rate of recidivism, is that based on that decrease in harm or level of severity? It doesn't mean that the person hasn't actually done anything, because I looked at some studies on recidivism and I realized, but it actually was kind of meaningless. It didn't mean that the pedophile hadn't done anything. It just meant that there was perhaps a less dangerous level. So a pedophile is perhaps touching, there isn't any penetration, and then everybody's happy because there's been some success.
I wouldn't be happy. You must be reading a different literature than me. I've never read a study that counted a reduction in harm as an index of success. All studies that I know of, and these are, I would
Moi,
guess,
j'en ai lu. Je pourrais vous les...
I did read some, and I could tell you which they are. So the rate of recidivism was based on that.
So we don't have this back and forth. We'll give Mr. Marshall just some time just to conclude his statements there. Go ahead.
All of the acceptable studies in the literature index reoffence rate by several things. One is, was he convicted of another offence? Was he charged with another offence, but the offence was withdrawn? Did he break conditions of parole? All of those we count as a reoffence. That's overcounting reoffending. And still, in this large-scale study, we have 5.2% recidivism in the treated group and 18% recidivism in the untreated group.
Thank you very much, Mr. Marshall. Mr. Davies.
Thank you, Mr. Chairman. As we know, there are two major parts to the bill before us. There's a proposal that would bar Canadians from getting a pardon if they commit more than 3 indictable offences. And you know, I think we've heard from every witness, including the minister, I think, who has said that that's an arbitrary figure that needs to be relooked at. And then the other aspect of this bill is a bill that would also bar any Canadian convicted of a long list of sex offences against children from ever being eligible for a pardon. And I think we have to say at the outset that I think when we talk about sex offences against children, it involves a level of protectiveness in this, and dare I say even repugnance and disgust that I think is common to everybody. And also it brings up in us a very strong desire to protect our children. And I think that's understandable. I think what we need to do as parliamentarians here is to try to make wise policy that will aid in that objective. And so I want to address these comments to the two people who have been spending their lives, I guess, addressing this. Does the prospect of obtaining a pardon, in your experience, aid in the rehabilitation of a person convicted of a sex offense against a child to the point where that person will never offend again? Is that part of the rehabilitation process then, or does it play a role or not?
I think where it plays a role is actually more in interfering with the process of rehabilitation. As I mentioned earlier, even just being able to get gainful employment. The people that I see have tremendous difficulty upon release from incarceration getting any type of a job. Over time, if there are people who know them well, who can see the whole person rather than just the offense and see how they've changed, they may get a job. But other people, it could be a lifetime process, or at least go until they get a pardon, when they can actually fill out an application where it says, do you have a criminal record, and they don't have to report that. So I think it's more that it interferes with that. The other thing is just the motivation. As I said earlier, it sends a very strong message to somebody. It's saying that there's nothing you can ever do that will make anyone believe that you have changed. That's very, very discouraging kind of message. The whole business of labeling theory says that if you call somebody something often enough and you define them a certain way, they begin to believe that themselves. If you believe you can't change, you stop trying to change.
Okay, Mr. Marshall, did you want to respond to that?
I just think it's part of the motivation that drives these men to engage fully in the process of rehabilitating themselves. I think that's very important, but I think it's, as Mr. Fletcher said, the very important thing is that part of that rehabilitation is being able to find a place in society where you can function well and meet the same kind of goals that the rest of us meet.
Okay, because what I think all of us on this committee are grappling with is if we pass a law that prohibits people who have committed that any one of those offenses in that long list of sex offenses against children from getting a pardon, is that a good public policy because it I guess it makes society know forever that those people committed that offense, or is that bad public policy? And I noticed the sentence you said, Mr. Marsh, you said no sensible country or community would give pardons to every sex offender. I think we all agree with that. So my question is would a sensible community deny pardons to every sex offender? It seems to be the corollary question that came to my mind.
No, I would think that's just as much of an error as giving pardons to all of them. I mean, these people vary remarkably in the kinds of things they do to children in their molestation, but also the frequency and their potential for rehabilitation. We need to offer people an encouragement to engage in an effective process of rehabilitation, really. I just think, I know better than anybody in this room, possibly with the exception of Mr. Fletcher, what sexual offenders, child molesters do to children, right? I've been doing this for 42 years. I find it really repugnant, so I'm not soft on these people at all. But we have to have a system that will motivate them to engage a process of rehabilitation and give them the opportunity to succeed in that process.
Right. I mean, we know that, nobody would ever give Paul Bernardo a pardon. I mean, nobody would ever give Carla Homolka a pardon. I'm wondering, is there any person who's committed a sex offense, like, for instance, let's say exposure, because I think exposure is one of the crimes listed, exposing yourself to a child. It sort of runs the gamut from that all the way to full-blown out rape of a child. I want to ask, is there anybody convicted of those offenses who you think can be cured? Because this is a question we all have is, I've heard people say they can never be cured, and I'm wondering, is that correct or not in your experience?
I think the term cure is inappropriate here. If I can just speak to the whole business of the disease idea, certainly sexual offense, pedophilia is not a disease in the sense that schizophrenia is, which is an organic process, okay? People commit sexual offenses against children because they choose to. It's a behavioral choice. People can be taught how to make better choices. They can learn that there are better ways of dealing with things, and that motivates them to make better choices. So if the question is, can you change people's behavioral choices, the answer is absolutely yes. And once those are changed and ingrained, they're changed forever.
Now, shouldn't we be safe, though? Shouldn't we just say, look, we can't take a chance when it comes to our children, so anybody who's convicted of these offenses simply should not get a pardon, and that's just the most prudent, safe policy to take? What would be your comment on that?
I would have difficulty seeing how not granting a pardon would protect children.
We'll now move to Mr. Norlock, please. Mr. Norlock.
Well, thank you, Mr. Chair, and through you to the witnesses, welcome, and thank you very much for your testimony. It is indeed very helpful. If I may begin my questioning by a statement that the complaint that what we say and do at committee gets reported in the House and it's hurtful. I have seen the very person who complained about that verbally eviscerate other people, and I guess in this political realm, in the cut and thrust, we somewhat share in some of those exchanges. Some of us have had to apologize, both to the House publicly and privately, and some of us have had to go through some legal pains. So I think what it does to all of us, and I would agree with him, that it demeans us all. Not just one of us, but it demeans us all. And I have to share in that. And I think the low opinion of the public, of politicians, is because of the actions we take, because we care very much about our stand and what we stand for, has an effect. But we're here today to talk about 23B. Chief Constable Lemke, I shared a profession with you before this one, and I guess I listened to the other two witnesses, and while I don't disagree with them, I'm always reminded of people in the law and in healthcare that they practice their trade. I don't ever recall hiring a carpenter who practiced carpentry. I always wanted to have an expert who knew what he was doing. So I think what I'm not being insulting there. I think I'm just saying that when you deal with human beings, there are no exact things that work for everybody, and this is a roundabout way of getting to you, Chief Constable. Is in my experience as a police officer, is we deal with the bad guy.
Mr. Chairman, I'm sorry, I have a point. Don't interrupt my friend.
I didn't go through the chair.
I'm just conscious of it's after 10:30.
We're going to get the first round.
Oh,
and
okay,
then
that's the decision that's been made.
Yep.
Please don't count this against
No,
me.
go ahead, sir.
Through you, Mr. Chair, to the Chief Constable, we deal with the person who committed the offense either shortly thereafter or as close thereafter as is reasonable under the investigation. But who we deal with immediately thereafter generally is the victim. And we tend, because we are in smaller communities in this country, to know what effects those have on the victim. Not only the victims, but on the victims' families. Mothers and fathers who divorce because they cannot withstand the pressures that have occurred because their child has been killed or sexually abused. And also, I would suspect, so I'm going to ask you to comment on that. And something that I am very familiar with is sexual abuse on boys, because we only hear about a third of them. Most of them aren't reported because boys don't like to be taught, don't like people to look at them knowing that somebody has abused them. Nor do girls, but boys especially, because they have that. So I wonder if you could tell us why you've given some of the responses you have, and some of the reasons why you're before this committee and your opinion on this as it reflects to your job.
Mr. Lemke.
Thank you. I'll speak then about victimization and with regard to this bill. When I hear the number of 535 people treated and only 5% repeat, 18% in untreated, the part that worries me, and I know that this bill focuses on pardons or record suspensions for offenders, and I don't believe that anybody's intentionally doing this, but there is very little talk about the victims, and that part concerns me. So does a pardon help the victim of this crime? I don't think it does. I read some of the previous minutes where Sheldon Kennedy spoke here, and it doesn't. I'm sure that that victim lives with this in some cases. Some people deal with crimes differently. Some will live with this horror forever. And how does that pardon help them? It's very nice that we talk about how it helps the offender, but how did it help the victim? We should, when it comes to crimes against children, do everything from beginning to end to prevent these crimes from happening. We should be saying to people, Canadians will not accept it, we will not tolerate this, we will treat this very harshly. From day one, if you do this, the courts are going to treat you harshly. You are never going to get rid of your record. All these bad things are going to happen to you if you do this, because we want to protect our children. And that is, I think, what we should really be focusing on with that part of this legislation. It's fine that I agree that people can rehabilitate. Maybe there are some pedophiles that can rehabilitate, but I also think it's more management of the issue that they're dealing with. And that part scares me tremendously, in that their record can be suspended. They could, and I know they'll be flagged on CPIC, but there may be ways that they can get themselves into a position where they're now working with children again. And if one child is hurt, that's one too many.
Thank you very much, and we appreciate all three of you being at our committee today and your expertise and your opinions on this bill. certainly will be I think, I hope that you follow up. I'll just make mention that, if you received a question and you've thought further about it in times to come, and you would like to submit another written response on it, we would, as a committee, gladly welcome that. So thank you. We're going to suspend for just 1 minute, and then we're going to move in camera. So I would encourage all others to exit the room fairly quickly, and we're going to have committee business for approximately 12 minutes. We'll suspend.